The law does not require an outdoorsman to answer any of the following questions. Hello everyone, my name is Joseph Radzwion IV, your trusted attorney with Radzwion Law, PLLC. And today we are looking at when an outdoorsman or an outdoorswoman has to produce their hunting license or show their hunting license to a DNR officer. We'll also have some Think Like a Lawyer tips at the very end, so stick around for those as well. When is an outdoorsman legally required to produce their hunting or fishing license? This area of the law can be found in MCL 324.43516. And essentially, there are two situations that this occurs. Situation number one, or the first situation, would be when a hunter or a fisherman is actually performing the activity of hunting or fishing. DNR officer walks up, they can ask to see that hunting or fishing license, and that outdoorsman is legally obligated to show that conservation officer their hunting or fishing license. The second instance when this comes up is when a outdoorsman is in the woods or in the field and they possess either a firearm or a fishing instrument or a hunting apparatus or trapping apparatus, essentially equipment that would help them or assist them in hunting or fishing or trapping. The other aspect of this requirement, though, is that the hunter or fisherman have to be in an area that wild game or wild animals could be harvested or that fish could be caught. So you're not going to need a fishing license if you're carrying a fishing pole through a cornfield. Now, if you're carrying a firearm through a cornfield, that might be a different story. In other words, if an outdoorsman possesses some sort of hunting or fishing equipment and they are in the area where they could use that equipment or that gear to either catch fish or hunt wild game, the outdoorsman will need to possess that license and show that hunting or fishing license to the DNR officer upon their request. The law does not require an outdoorsman to answer any of the following questions. How many fish did you catch? Who caught the walleye? Who caught the perch? How many deer have you harvested this season? How many points, antler points, were on the buck that was harvested? Where did you field dress that animal? None of these things are required to be answered by the outdoorsman. In other words, the outdoorsman always has the right to remain silent. Even truthful, respectful answers that an outdoorsman may want to give can be used by that DNR officer as part of their investigation in collecting facts and collecting evidence to either arrest that outdoorsman or request charges be issued by a prosecutor. This is why an outdoorsman should be prepared to say something to the effect of, "Officer, here's my hunting license. I now wish to remain silent, and I do not consent to any searches or seizures of my property." Now, the outdoorsman should obviously say this very respectfully and politely, and an outdoorsman should never physically resist the law enforcement officer during their investigation. Some helpful tips to think like a lawyer. Number one, the outdoorsman is going to need to actually carry and possess the physical or electronic copy of their hunting or fishing license while they were performing one of the described activities. Also, a hunter or a fisherman need not produce a driver's license to that law enforcement officer while they are engaged in fishing, hunting, or trapping. Most importantly, an outdoorsman should remember their Fifth Amendment right to remain silent and that right does not disappear just because the outdoorsman has given their hunting or fishing license over to the DNR officer. In conclusion, an outdoorsman should be prepared to present their hunting or fishing license to any DNR officer while they are engaged in the activity of hunting, fishing, or trapping. If you support hunting here in the state of Michigan, hit that thumbs up button, leave us a comment below, and consider subscribing to our channel if you like videos like this one. Thanks for watching. We'll see you next time.